Your Honor, we have read over the pre-sentence report and recommendation. We have no corrections, deletions, or additions. I would like to make comments on behalf of Ms. Johnson before the court imposes sentence. You may proceed, sir.
Before the court even begins discussing punishment, it's important to understand exactly what stage of the legal process we're watching. This is the sentencing phase, and by the time a case reaches this point, the court has already determined guilt through a plea or conviction. Now the judge must decide what the consequences will be. And immediately we hear both parties referencing something extremely important, the pre-sentence investigation report, often called the PSI. This report is one of the most powerful documents in a courtroom during sentencing. It compiles the defendant's criminal history, employment, personal background, treatment history, and probation recommendations. Judges rely heavily on it because it helps answer a critical question. Is this person likely to reoffend? Right away, the defense attorney begins shaping the narrative. That's not accidental. In sentencing hearings, lawyers try to show the judge the human side of their client, their struggles, responsibilities, and efforts to change. The defense is already hinting that there may be mitigating circumstances behind what happened here. This opening moment sets the tone for the entire hearing. Will the judge focus strictly on the offense itself, or will the surrounding circumstances play a role in the final decision? As the defense begins presenting their argument, listen closely to how they frame the situation, because in court, the story behind the crime can sometimes influence the sentence just as much as the crime itself.
Was there anything from the people on this?
Your Honor, we would support and ask the court to adopt probation's recommendation as written.
All right. Go ahead.
Judge, with respect to the recommendation, it is fair, it is appropriate. However, there are some things the court should know. One, this incident was triggered by a personal health scare for Ms. Johnson. She had a diagnosis of a breast cancer potential, and this particular event comes on the heels of two that occurred more than 22 years ago. There have been no appearances in court. There have been no steps taken by her since back in 2001 and 2002 on the previous situations. Kathy works two different jobs, Your Honor, to support herself. Coming here today, she has made arrangements to immediately serve at least the minimum jail sentence, taking time off from her jobs. I have come to know her since being involved as her attorney as a very responsible lady who understands the gravity of what occurred here. She has participated in Dawn Farms program. She has been here cooperating with the court, with probation, with whomever at every step of the way. I think, Your Honor, that the court should show some kind of leniency in terms of the fines and costs to allow her time to make payment. They total over $2,000, 24 months of probation. She just needs time to pay. And Your Honor, I believe that she would like to make a statement on her own to the court.
Very good. All right. Ms. Johnson?
You can go ahead.
My name is Kathy Renee Johnson. I realized I made a mistake because I could have harmed other people. And I've been attending AA meetings, and I put myself in Domino's Farm on my own, and I've been working two jobs.
What we just heard is one of the most emotionally important moments in a sentencing hearing. The defendant's allocution statement. This is when the defendant has the opportunity to speak directly to the judge before punishment is decided. Courts take this moment very seriously. Judges want to know whether the defendant actually understands the consequences of their actions. A statement like this can influence whether the court believes the person is capable of rehabilitation. Notice the key elements in her statement. She acknowledges that her actions could have harmed others. That shows an understanding of the potential impact of the offense, which judges often look for when evaluating remorse. She also mentions attending AA meetings and entering treatment programs voluntarily. Those details matter because they show efforts to address the underlying issue that led to the offense. In many cases involving alcohol-related crimes, courts prioritize treatment programs because they are designed to reduce the likelihood of repeat offenses. But the real question here is credibility. Judges hear apologies every day in courtrooms across the country. What they're evaluating isn't just the words. It's whether the defendant's actions demonstrate genuine change. And as this hearing continues, the judge will now have to decide something crucial. Is this apology evidence of real accountability or simply a last attempt to avoid a harsher sentence?
And I realize I made a mistake and I'm sorry for what I done.
Court does acknowledge this is not a serious misdemeanor defined by statute, however, believes there are reasonable grounds to depart with the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, AA attendance, and monitored abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is the sentence of the court. You're placed on 24 months of probation. You're to pay $1,055 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $720 probation oversight fees. When can that be paid? How are you going to pay that?
I'm gonna pay it when I get paid if I can. On a monthly thing, I would like to be on a I would like to be on.
How much do you believe you can afford to pay of that per month, ma'am?
At least $100 a month.
Pardon?
I could pay $100 a month.
Now we're seeing another very practical part of sentencing that many viewers don't realize can become a serious issue for defendants: court financial obligations. When someone is sentenced, it's rarely just jail or probation. There are often multiple layers of financial penalties. In this case, the judge lists several costs: court fines, prosecution recovery costs, police agency recovery fees, and probation oversight fees. When you add all of those together, the total exceeds $2,000. For someone working multiple jobs, that can be a significant burden. Courts typically establish payment plans to make these obligations manageable. Here, the judge asks a simple but important question: how much can the defendant realistically afford to pay every month? The defendant proposes $100 per month, which the judge ultimately accepts. But here's something interesting about financial penalties in the justice system: these payments are not optional. Failure to keep up with court-ordered payments can lead to probation violations, additional penalties, or even jail time in some circumstances. So while probation may seem like a lighter sentence compared to incarceration, it still comes with strict responsibilities. The defendant must follow treatment programs, attend meetings, avoid substances, and stay current on payments, all while maintaining employment. And that raises an important question: should financial penalties play such a large role in criminal sentencing, especially for defendants who are already struggling financially?
My check is being garnished right now.
I think we'll be able to. All right. I'll set your payment plan at $100 per month. That will begin in August. It may be readjusted by probation just to make sure that you're going to be able to get that all paid prior to the point in time of the end of your probation. There should be no alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You'll complete the non-farm outpatient program, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation. Mr. Allen, I'll order 365 days in jail, credit for 1 day served. I will remand you to the Washtenaw County Jail to serve an additional 4 days, and then the balance will be suspended. Defendant is remanded. Thank you.
Thank you, Your Honor.
Morning, Judge Calbrell, on behalf of Ms. Hafner. He's approaching the podium. Ms. Hafner, please say your name for the record.
Jessica Hafner.
Thank you.
The courtroom now shifts to an entirely different case, and this transition highlights something unique about many district court proceedings. Judges often handle multiple cases in rapid succession during a single session. The next matter involves a defendant named Jessica Hafner, and the defense attorney immediately requests an adjournment. An adjournment simply means asking the court to postpone the hearing to a later date. This often happens when attorneys are newly appointed and need time to review evidence, police reports, or witness statements before proceeding. But there's another important issue raised here: a no-contact order involving the defendant's children. These types of orders are typically issued when the court believes contact between the defendant and certain individuals could pose a risk while the case is ongoing. The defense attorney explains that 2 of the children have serious hereditary medical conditions requiring advanced treatment. Because of that, the defense is requesting a modification that would allow supervised contact strictly for medical purposes. This is where things become complicated. Courts must balance 2 competing priorities: protecting potential victims while also recognizing family responsibilities and medical needs. And as the prosecution begins describing the allegations that triggered this order, the judge now has to determine whether changing that restriction would be safe, or whether it could create further risk.
And Your Honor, I was just very recently appointed on this matter. We are asking for a brief adjournment at this time.
July 17, 2025, 9 a.m. Bond continued.
Thank you. Judge, if the defense may be heard as to bond.
She's out. 17.
Thank you, Judge. So Ms. Hafner currently has a no contact order with her children. 2 of her children have a bad hereditary condition that requires constant and fairly advanced medical treatment. There could be a hospitalization or, I believe you said, a surgery, sort of at any given time. Name of the disease was too complicated and long for me to even write down here, but we are asking for a modification to the no contact order to allow supervised contact for the purposes of medical treatment only.
Response from the people.
We would ask that the bond remain set where it is until we can have an exam or resolve the case.
I mean, is CPS involved?
Yes, Your Honor.
Is CPS?
I'm looking, a referral was complete at the time of this investigation.
Right.
They're pacing it.
How many children are involved in this? 1?
Elijah appears to be the victim.
This is only 1 child named in the complaint, Judge, yes.
As far as the victim. I mean, I was concerned, Your Honor, when the police came to investigate, the defendant took a long time to answer the door. She said that he was sleeping and they needed to check the welfare of Elijah. He was in his bed covered with a blanket, but not sleeping. They immediately observed blood coming from his face as well as tears from his eyes and blood on the chin. So we would ask that bond continue. I don't think it's appropriate for her to have contact with any patient.
This is the moment where the tone of the hearing shifts dramatically. The prosecutor's description of what officers saw during the welfare check is extremely serious. According to the statement, when police arrived, they found the child lying in bed with visible blood on his face and tears in his eyes. Allegations involving injuries to a child immediately trigger heightened scrutiny from both prosecutors and judges. Courts treat these situations very carefully because the primary responsibility of the justice system is protecting vulnerable individuals, especially minors. You also heard the prosecutor clarify something important. The child who was allegedly injured is not one of the children with the medical condition that the defense referenced earlier. That detail may influence how the judge evaluates the request to modify the no-contact order. In these situations, judges often refuse to change protective conditions until they have a complete written motion and supporting evidence. That ensures the court has time to review the facts thoroughly rather than making a quick decision in the middle of a hearing. And that's exactly what we see here. The judge declines to modify the order immediately and instructs the defense to submit a formal written motion if they want the request reconsidered. It's a cautious approach designed to prevent rushed decisions when a child's safety may be involved.
And for what it's worth, Your Honor, Elijah is not one of the children that has the condition.
Well, but I'm not, you know what? I tell you what, I'm not going to change this, and I'm not going to change this on the fly, certainly. I believe that it should be changed. File a written motion, I'll hear it, but I'm not going to do that. Motion for bond reductions tonight at this time, or bond modification is tonight.
Understood. Thank you, Judge.
Hello, Your Honor.
Hello, your name?
Eric James Casey.
Sir, you're here on an arraignment on 2 charges. The complaint alleges that on or about July 18, 2024, at the location of
This courthouse.
33.
Yeah, it all happened in
Are
this
you
courthouse.
going to interrupt
I'm
me?
sorry.
Or are you going to let me continue with your arraignment?
Okay, I'm sorry, sir.
Which way you want to do it?
I'm not going to interrupt you.
Thank you. Complaint alleges that on or about July 18, 2024, at the location of 4133 Washington Avenue in Pittsfield Township, Washington County, State of Michigan, complaint alleges that you did make an assault and battery upon a Joseph Crossley. Do you understand the nature of that charge, sir? And I'm not asking you whether or not you did it. Do you understand what you were charged with?
Yes.
That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. This could be a consecutive sentence. And if a consecutive sentence can be imposed, if this did occur within a place of confinement, you understand the nature or the penalties in this case.
Yes.
Now the court moves on to another defendant entirely, Eric James, who is appearing for an arraignment. An arraignment is the first formal step in a criminal case where the judge reads the charges, explains the potential penalties, and asks whether the defendant understands them. The judge makes it very clear that the defendant is charged with assault and battery along with a disorderly conduct offense. Both are misdemeanors, but they still carry serious consequences, including possible jail time and fines. One interesting moment here occurs when the defendant says he doesn't recognize the individuals involved in the charge. The judge quickly clarifies something important. The arraignment is not the stage where guilt or innocence is argued. The only purpose right now is to ensure the defendant understands the charges in the legal process moving forward. You'll also notice the judge repeatedly asking whether the defendant understands. Courts do this intentionally to ensure that the defendant cannot later claim they were unaware of the charges or penalties. This is also the moment where the defendant requests legal representation, leading to the appointment of a public defender. That ensures the defendant has legal counsel moving forward in the case.
You understand that?
Yes.
Count 2 on that complaint alleges that on that same date and at that same time, you did commit the offense of disorderly person jostling. Do you understand the nature of that, sir?
No, because I don't even know these people. The only person I know is
Do you
Joseph.
understand what you are charged with?
Well, I know what you're charging me with, sir, but
I am not charging you. Do you understand what you are charged with in count 2?
no.
All right, let me just do it formally then. July 18, 2024, the location of 4133 Washington Avenue in Pittsfield Township, Washington County, State of Michigan. Count 2 specifically alleges that on that same date and at that same location that you were a disorderly person. To wit, a person was found to be jostling or roughly crowding people unnecessarily in a public place at that location. Do you understand all of that, sir?
I understand all this.
That is a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. Do you understand those penalties?
I understand this, Hunter.
Do you wish to be represented by an attorney?
Yes, I guess so, Hunter, because you didn't let me
Public
speak.
defender case.
This is the public defender Natalie Pate with and on behalf of Mr. Casey. We would waive any further reading. My client stands mute and we would ask for an adjourned pre-trial date as well as a PR bond, please, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be adjourned to July 16, 2025 at 9 a.m. I will set the defendant's bond in this case, amount of a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of any weapons or anything fashioned to be a weapon. Do you understand that, sir?
Oh, yes.
Do you understand also that I am going to order no possession or consumption of any alcohol, recreational marijuana, or any illegal drug?
Yes.
I will also order that you are not to have any contact whatsoever with Joseph Crossley.
Don't want to. I'm sorry, sir.
You are really wearing on me.
I'm sorry, sir. I'm just trying
Do
to.
you understand the order? That was a question. Do you
Yes.
understand you are to have no contact with Joseph Crossley?
Yes. I give it a handle. I'm sorry.
He gets one more time.
I'm sorry.
I'm changing the bond.
I'm sorry.
Is there any other request of conditions from the people?
There is a request for a no go to, Your Honor, an address. May I give that to the court?
No go to, yes, go ahead.
102 Talladay Road, Talladay in Willis,
Do you have any reason to
Michigan.
address?
48191. That'd be better.
Any objection to that, counsel?
No, Your Honor.
All right, I'm going to order that there is no go to that location, 1025 Talladay Road, Willis. Thank you.
Thank you. Sorry, Judge.
As this hearing concludes, the judge sets a $5,000 personal recognizance bond, often referred to as a PR bond. Unlike a traditional cash bond, a PR bond allows the defendant to remain free without paying the full amount up front, as long as they promise to appear for future court dates and comply with the court's conditions. However, that freedom comes with strict rules. The judge orders no assaultive behavior, no possession of weapons, and no contact with the alleged victim. The defendant is also prohibited from consuming alcohol or illegal substances during the case. Violating any of these conditions could result in immediate arrest and revocation of the bond. Throughout this courtroom session, we saw several different aspects of the justice system in action: sentencing decisions, probation conditions, protective orders, and arraignment procedures. Each moment highlights how judges must constantly balance accountability, rehabilitation, and public safety. Courtrooms operate on careful procedure, and every ruling, and from payment plans to no contact orders and warning, is designed to manage risk while ensuring fairness in the process. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.